Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn something useful about the law while you enjoy your lunch. In the last show, we talked about the registration of marks, slogans, brand names, logos, and how they can enhance and protect an important business asset. Today, we'll talk about a similar topic, copyrights. Our founding fathers understood the importance of protecting the arts and sciences. In Article 1, Section 8, Clause 8 of the United States Constitution, our founding fathers wrote, "The Congress shall have power to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries." Congress did just that. The Copyright Act of 1790 was the first federal copyright law. It was enacted in May of 1790, with the first work being registered within 2 weeks. Originally, copyright claims were recorded by clerks in the U.S. district courts. In 1870, copyright functions were moved over to the Library of Congress, where they exist today. By the way, the first copyright was the Philadelphia Spelling Book by John Barry. It was registered in the U.S. District Court of Pennsylvania in 1790. Well, a copyright is a bundle of rights that vest in the author of certain works. The author is the one who created the work. Possession is not the same as ownership and authorship. So the bundle of rights that the author of a work has under the law include these: the right of reproduction. For example, under the law, if you write a song, no one else can reproduce it without paying you a royalty. The royalty rate is set by the government, and it defines the maximum amount that must be paid to the songwriter for each reproduction. Other rights include, in this bundle of rights, include for derivative works, transmission, distribution, performance, and public display. So here are some categories of authorship. It's for literary works, musical works, dramatic works, collective works, derivative works, and compilations. Here are some examples of works that are eligible for copyright protection: books, catalogs, musical compilations, paintings, sculpture, software, photographs, film, and choreography. On choreography, no, Michael Jackson did not copyright the moonwalk, but he did obtain a patent for the gravity-defying shoes he wore in the video for Smooth Criminal. And lastly, architectural designs. All of those types of works can have and enjoy copyright and copyright protection. Well, how long does the copyright last? Generally, for works created after 1978 or after January 1st of 1978, copyright protection lasts for the life of the author or copyright owner, plus an additional 70, 95, or 120 years, depending upon the nature of the authorship. Now, there is no legal requirement to register a copyright in order to own the rights to works you've authored. That's because the author of a work receives common law protection for his authorship, but it's critically important to register one's copyrights. Now, here are some advantages to registration. For example, you must register, or at least apply to register, your work if you want to sue someone else for infringing your work. And also, another example is you must have registered your work before a violation. If so, this provides an alternative basis for statutory as opposed to actual damages. So you have to register your work before there is a violation if you want additional damages against the person who has violated your work, other than just the actual damages that you sustain. And these other additional damages that you get from registering your work can be substantial. For non-registered works, that is works that receive only common law copyright protection, you may only receive actual damages and disgorgement of profits by the person who has violated or infringed your works. But registered works have the potential to receive statutory damages of anywhere from $750 to $30,000 for each act of infringement, and it's up to $150,000 for willful infringement. You can also recover attorney's fees if you register your work. You also have the ability to have a court impound the violative works, and there are other remedies that are available to you for registration. Well, let's talk a little bit about copyright infringement. Do you remember Vanilla Ice, the singer from the 1990s? Vanilla Ice had a hit in 1991 with Ice Ice Baby. It sampled but did not credit the song Under Pressure by David Bowie and Queen. Though he first denied it, Vanilla Ice later retracted his statement, saying that his denial was only a joke. He was facing a lawsuit by the duo, by Queen and David Bowie, for infringing their right to the song Under Pressure, when Vanilla Ice essentially used it for his song Ice Ice Baby. Vanilla Ice eventually fessed up to sampling the work. He was sued. The case was settled privately out of court, with Vanilla Ice paying an undeclared sum of money to David Bowie and Queen, and crediting those David Bowie and Queen on his track for the work. So Vanilla Ice paid probably a very significant sum of money for infringing upon the song Under Pressure, which was a registered copyright to David Bowie and Queen. So registering your rights to works you've authored can add immense value to your work should it become a hit. Remember the story of Dolly Parton, who wrote the song I Will Always Love You, and she turned down Elvis Presley, who wanted to record it because he wanted half the copyrights to the song. Dolly said no to protect herself financially. When Whitney Houston later came around and performed that awful, overwrought version of Dolly's beautiful ballad, Dolly became even richer because she held the copyright and had refused to share it earlier in her career with Elvis. So the lesson is that whenever you author a work, whether it's a song, a book, a software work, photography, sculpture, paintings, and others, you think it may have some commercial value, make sure you take the steps necessary to register your work with the U.S. Copyright Office. That will provide significant protection and add great value to you. For more information on copyrights and trademarks, you can give me a call at 717-657-7770. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned something useful about copyright law. Enjoy your lunch.